You've been injured in an accident in Florida, and the insurance company just made you an offer. But how do you know if that number is fair when you have no idea what your case is actually worth? In this video, I'll break down how personal injury cases are valued in Florida, what factors drive your settlement up or down, and the mistakes that cost victims thousands without them ever realizing it. Hey, Attorney Patrick here from Hale Law. If you or somebody you know were injured and want to speak with an attorney you can trust, call me at 1-800-800-1414. The call is free and confidential, and we will walk you through how to fight like Hale so you can get the maximum compensation you deserve. Let's start with something most people get wrong from the beginning. They think their case is only worth what their medical bills add up to. It's not even close. Florida law recognizes multiple categories of damages, and if you don't know what they are, you'll almost certainly leave money on the table. The first category is economic damages. These are your measurable financial losses. Medical bills are the obvious one, from emergency room visits to surgeries to physical therapy, but it goes deeper than what you've already spent. If your injuries require future treatment, ongoing medication, or specialized equipment, all of that gets factored in. Severe injuries can mean hundreds of thousands of dollars in lifetime care. If you've missed work because of your injuries, those lost wages are part of your claim. And if your injuries prevent you from doing the same job you did before, your reduced earning capacity over the coming years becomes a major piece of the equation. Even expenses people forget about, like transportation to medical appointments or hiring someone to help around the house. This all counts towards your economic damages. The second category is where insurance companies really try to shortchange. Non-economic damages cover the losses that don't come with a receipt but still change your life. Pain and suffering, both the immediate trauma and any chronic pain that follows. Emotional distress, like anxiety, depression, or fear of driving again. Loss of enjoyment of life, meaning the things you used to do that your injuries have taken away from you. And loss of a consortium, which compensates your spouse for the impact your injuries have had on your relationship. Now in Florida, for auto accident cases specifically, you generally need to prove a permanent injury to recover pain and suffering damages. That means significant and permanent loss of a bodily function, permanent scarring or disfigurement, or even death. This is a legal threshold that matters, and it's one of the many reasons having an attorney evaluate your case early makes a real difference. In rare cases involving extreme misconduct, like a drunk driver or a trucking company that knowingly ignored safety regulations, Florida also allows punitive damages. These are designed to punish the wrongdoer rather than just compensate you. They're uncommon, but when they apply, they can significantly increase the total value of your case. So now that you know what types of damages exist, let's talk about what actually moves the needle on your settlement amount. The severity and permanence of your injuries matter more than almost anything else. A broken bone that heals in 3 months is valued very differently than a spinal injury that changes how you live for the rest of your life. Insurance companies know that juries award substantially more for permanent visible injuries, and that affects what they're willing to offer in settlement. Liability strength is the next major factor. If the evidence clearly shows the other party caused the accident, the insurance company knows they'll lose in court and they're more motivated to settle fairly. But if fault is disputed or if the evidence is thin, they'll push back harder. Clear police reports, witness statements, surveillance footage, and consistent medical records all strengthen your position. Your own credibility matters too. If your treatment history is consistent, you've followed your doctor's orders, and your story hasn't changed, that builds trust. Insurance companies investigate social media, run background checks, and look for any inconsistency they can exploit. And then there's the factor most people don't think about until it limits them: insurance coverage. The at-fault driver's policy sets a practical ceiling on what you can recover from their insurer. If they carry the minimum coverage, your settlement options from that policy are limited regardless of how serious your injuries are. This is where your own uninsured or underinsured motorist coverage becomes critical. Commercial defendants like trucking companies or large businesses typically carry much higher limits, which is part of why those cases often result in larger settlements. Now let's talk about timing, because when you settle matters just as much as how much you settle for. Most personal injury cases follow a predictable path. First, you focus on treatment and recovery while your attorney investigates, builds your case. During this phase, insurance companies frequently make early settlement offers, hoping to close the file before you understand the full extent of your injuries. These early offers almost never reflect fair value. Once your treatment concludes, or your doctor says you've reached maximum medical improvement, your attorney puts together a comprehensive demand package, which documents everything: medical records, bills, lost wages, expert opinions on future care, and evidence supporting your pain and suffering. That's when real negotiations begin. Most cases settle during this phase without ever going to court, but having an attorney who's prepared to file suit if the offers stay unreasonable is what keeps the insurance company honest. And for timing, keep this in mind. Florida shortened the statute of limitations for most negligence cases to 2 years for incidents after March 2023. Wait too long and you lose your right to compensation entirely. Finally, let me cover the mistakes that quietly destroy case value. Giving a recorded statement to the insurance company without legal counsel is one of the biggest. Adjusters ask carefully worded questions designed to get you to minimize your injuries or accept partial blame. That recording becomes a permanent part of your file. Settling before you understand the full scope of your injuries is another costly error. Once you sign that release, there's no going back for more money, even if your condition worsens. And don't overlook Florida's comparative negligence law. If you're found to be 51% or more at fault, you recover nothing. Insurance companies aggressively look for ways to shift the blame onto you. This is why having someone in your corner who knows how to counter that matters from day one. If you've been injured in an accident in Florida and you want to know what your case is really worth, call us at 1-800-800-1414. The consultation's free and confidential, and we'll give you an honest evaluation so you never have to guess whether the insurance company is being fair. When you're hurt, go to Hale. And if this video was helpful, hit subscribe for more legal guidance and check out our next video.